Are you an inventor? Have you ever thought about inventing? Well, welcome to the United States Patent and Trademark Office. We're going to talk today about the understanding the basics of intellectual property and how it can help you on your invention journey. Here's a disclaimer. I'm going to talk about some products and services today, but we are not endorsing any of these products or services. We're strictly using them for educational purposes. So let's jump right in. The objective of today's workshop is just to go over an overview of what intellectual property is and how it can potentially benefit you as an inventor or a business owner. There's 4 types of intellectual property we will talk about today. First, we're going to talk about patents. Then we'll discuss a little bit about trademarks. We'll talk about copyrights. And lastly, we will talk about trade secrets. What's important to know about intellectual property is we're referring to creations of the mind. Something that you create, an invention, a poem, maybe a logo that came from your brain. Nobody else's but yours, a creation of your mind. Patents and trademarks protect, and copyrights and trade secrets, they offer different types of protection. We'll talk a little bit about that today so you can help distinguish between the 4 different types of intellectual property and which one or maybe all might help you. You're not limited to only one form of intellectual property. If you think that patents, trademarks, copyrights, and trade secrets, all 4 will help your business or help you, then you are more than welcome to have protection by all 4 types of intellectual property. Intellectual property, these are property rights. They are for a limited term. They do not last forever. And they're also territorial. There's no such thing as a worldwide patent. If you file a patent application in the United States and you are granted that patent in the US, well, you have protection in the US and its territories, but you do not have protection in foreign countries. So you need to understand that if you're going to do international business, then you're going to have to understand the laws of whatever countries you are going to be doing business in. Patents, these are government-given grants on property rights in exchange for public disclosure. What does that mean? Well, it means that when you file a patent application, you need to include all the information on how to make and use your invention. And what we will do in turn is we will publicly disclose that knowledge for the world. And if you're granted your patent, people can look up your patent and understand how to make and use your invention, and that will inspire them to potentially improve upon your invention or add on to it and make it do different things. And so that is how technology advances. Inventors are inspired from previous inventions. If you look at light bulbs today, they do not look like what the first light bulb that was patented looks like. They've evolved. Airplanes, trains, cars, bicycles, everything has evolved through inspiration. Somebody invented something and somebody saw that invention and they were like, wow, that's awesome. What if we added this to it? That's the beauty of the patent system. There's 3 types of patents. The first we're going to talk about is design patents. Design patents protect the ornamental look and feel of an object. We don't care what it does or how it functions. We're just worried about the characteristic look of this object. Design patents last 15 years from the date that they are issued. 15 years from the date that they are issued. Think of things like toys, or a car manufacturer comes out with a new car design, or a sneaker manufacturer, a new sneaker design. And neither of these companies want somebody to copy their designs, right? Video game manufacturers. If you look at a video game, if you look at a PlayStation or an Xbox, you can tell without seeing a logo or a name just by looking at the container that video game comes in, that console comes in, and you know where it's from, right? And so those are protected through design patents. The second we're going to talk about today is plant patents. So plant patents are given to asexually reproduced plant varieties, and they have to be discovered in a cultivated setting, which means you have to be able to repeatedly asexually reproduce your plant. You cannot just go into the woods and pick a flower and send it to us to get a plant patent. You have to show that you can reproduce this new variety that you've created. There's all different kinds of plant patents out there. Apples. There's a bunch of different apples that have been created by placing maybe an apple that grows well in a cold weather environment, but maybe that apple's on kind of on the small side with another apple that maybe is large. It's a large, very delicious apple, has good qualities, but unfortunately it doesn't grow good in cold weather. So maybe you're combining those two types of apples together to get a bigger apple that grows well in cold environments. There's many different things that you can do. Seedless watermelons, the poinsettia plant is another example of a plant patent. There's lots of different things out there that have been protected through plant patents. Lastly, we're going to talk about utility patents. 90% of the time when you hear the word patent, most likely that person is referring to a utility patent. Utility patents protect inventions that fall within 4 statutory categories: a process of making or a process of doing something, a machine. Think of a bicycle, a bunch of different parts put together that work to do something. That's considered a machine. An article of manufacture or a product that's made, like a frisbee, or a lots of different things, a baseball or a football, lots of different things that can qualify as a product that's made. Lastly, the 4th statutory category is composition of matter. Maybe you're trying to create some sort of new glue or adhesive surface that can go on tape that can stick in wet environments, because when it gets wet, this tape is falling off the wall and you need to stick something maybe in a shower or a wet environment. So you come up with some sort of new composition that is able to still stay sticky, but also work in wet environments as well. So that would be an example of what could qualify as a composition of matter. When we're talking about utility patents, the term of service is 20 years from the date of filing. That's the protection you get. And you also get 20 years from the date of filing for plant patents as well. And so what a patent is, remember we talked about rights? It's an exchange, right? The government grants rights. Well, so the government is granting you the right to stop others from making, using, selling, and importing your invention in the United States. What a patent does not give you the right to do is to actually make your invention. So in certain, that's a little confusing, right? Well, if I have a patent, why can't I make my invention? Well, maybe you can make your invention, but you need to understand that you potentially could be infringing on somebody else's patented invention in order to make your invention. So for example, if I'm an inventor and you're an inventor, I invented the light bulb, the first light bulb, and you read my patent and you saw the light bulb and you were like, wow, that is an amazing invention. However, while you're reading the patent and you're looking at my invention in use, you realize that light bulb is not very bright and it doesn't shine a light on a large area. So you came up with this new frosted diffused light bulb where the glass is diffused, and so when the light hits it, it scatters and it shines a brighter light on a larger surface area. So you get a patent for this new diffused light bulb. However, my patent is still valid. So in order for you to make your light bulb, you would need to make my light bulb and then add on to it. So you would need my permission first. So I would have the right to stop you from making your light bulb, because in order to make your light bulb, you need to use my patented invention. And that's where things like licensing come into play. So if you want to go and license someone else's technology so you can make your product, or maybe you're licensing your technology to somebody else. But that is how the patents work. They give you the right to exclude others from making, using, selling, and importing to the United States. So what is a trademark? Well, a trademark is any word, name, symbol, or device, or combination thereof that is used to identify the source of a product or service and distinguish itself over its competitors. It's very important, that second part, right? So there's 2 parts. It distinguishes between the source. It distinguishes the source of a product or service, but it also distinguishes your company over a competitor's company. So when somebody sees that logo, they know that it's your company and not someone else's company. So when I go into the grocery store and I go find my favorite cereal, which for me happens to be Frosted Flakes, who am I looking for? Well, I'm looking for Tony the Tiger, because I know if I see that tiger on that box, I know that distinguishes that cereal from all the other cereals in the aisle. And so I'm going to grab that box and I'm going to run home and I'm going to enjoy that delicious Frosted Flakes. So as you can see on this screen, there's all different kinds of trademarks, right? And so they can qualify. You see a TM stands for trademark, the SM stands for a service mark, and then you have the encircled R. If you see the encircled R, that means that that trademark has been federally registered with the United States Trademark Office, right? So that you can only use the circle R if it's federally registered with the Trademark Office. Federally registered trademarks give you lots of different advantages. You have the right to enforce nationally, not just locally within your state or your region, but nationally in all the states and territories. You can use a federal trademark registration symbol, like I just talked about, the R with the circle, the encircled R. You have the right to record your trademark with customs, right? And there's other rights that are conferred to you through federally registering your trademark. So a quick, there's an overview of registered trademarks, as you can see on the screen. If you attend Austin Community College, then you may be familiar with these trademarks, but these are some federally registered marks from Austin Community College. I see you're the River Bats. That's a pretty cool logo with the way the V turns into that bat like that. Austin Community College with the star right there as well. These are some other trademarks that you may see around campus. These are actually slogans. So these aren't the words or the symbols in the names, but this is like a tagline or a slogan. And as you can see, trademarks are classified. So you come in and you get a registration in certain classes. So this trademark is for use. It's a little small, so I'll read it on the screen, but it's for bumper stickers or daily planners, decals, decorative decals, vehicle windows, event programs, pencils. The list goes on, but that's the category that this trademark is registered under and can be used under. So if you see I am AC around campus, know that that's a federally registered mark. Start here, get there. This one was most recently registered July 11th, 2023, so a little over a month ago. So if you see this one around campus, start here, get there, understand that that's a federally registered mark of Austin Community College. Pretty cool, huh? So quick overview. What do trademarks do? Well, they allow consumers to identify the source or producer of different products and services, which helps them make their buying decisions. And they also encourage trademark owners to provide goods and services of consistent quality. This helps them build goodwill within their customer base so that the customers understand every time they go with that product or that service, they understand the level of quality they're going to receive through that. And so it really helps build up brands. So that's why trademarks are important. Trademarks also last how long? I didn't say how long they last, right? They last forever, as long as they're being used in commerce. So as long as your trademark is in use, then you have trademark protection. Now, if it's a federally registered trademark, then you have to maintain your maintenance fees and you have to be using it in commerce. And then it will last as long as you're in business. So that's one thing that trademarks has over patents. Patents last 20 years from the date of filing. However, trademarks last a little longer as long as the fees are maintained and they're being used in commerce. So for all my trademark friends out there, kudos to you. So moving on to copyright. Copyright's a form of protection provided by the laws of the United States to authors of original works of authorship. This includes literary, dramatic, musical, artistic, and certain other intellectual works. Copyright is actually a bundle of rights. So if you have a copyright, it gives you the ability to make copies of your copyright, prepare derivative works. What that means, derivative works are making your or modifying your copyright in a way that is a slightly different, but it's a derivative of your work. So you have the ability to make derivatives of your own work. You can distribute copies. You can perform the work publicly, and you can also display your work publicly. The Library of Commerce administers registrations, but the United States Patent and Trademark Office advises the executive branch, the White House, on intellectual property issues that also include copyright. So we also have copyright experts at the US Patent and Trademark Office. When you see the encircled C symbol, that doesn't necessarily mean that it's registered with the Library of Commerce. The Copyright Office is within the Library of Congress. And if you register your copyright, then that doesn't necessarily, if you don't register it, doesn't necessarily mean that you can't use the C. You can use the C and circle anytime you put pen to paper and you've created that copyright. You're going to want to go ahead and put that circle C on, throw your name and the date on there so people are aware that that's your copyright. So these are copyrights are secured automatically. Like I said, the minute you put pen to paper, that copyright is established, right? You got to fix it. It's called fixation. It has to be on a fixed, tangible medium. But once that work is created and it for the first time, you have copyright protection. There's no publication or registration protected for that. Now, copyright protection lasts 70 years plus the life of the author, for those keeping track. 70 years plus the life of the author. Lastly, we're going to talk about trade secrets. So trade secrets are exactly what the word says, secrets. The US government, we don't want to know. Please don't tell us, right? All the three other ones we talked about, copyright, trademarks, patents, those are things you come to us for and we help you get that protection. But with trade secrets, we don't want to know anything about it. In fact, we can't know anything about it. Otherwise, it will no longer be considered a trade secret. So one important thing to understand, your trade secret can't just be something that's generally known or easily found online or somewhere else. It has to be a secret. It has to be information that gives you an economic, a competitive advantage over your competitors. All right. And they could be different things like formulas, recipes, techniques, processes, devices, methods of doing something. Those could all constitute a trade secret. Interestingly enough, trade secret law dates back to the 1800s. So these trade secrets have been around for a while. All states do have some sort of trade secret protection in their policies or their laws. But why are trade secrets so useful? Well, once again, with the other forms of intellectual property, you're sharing information with us, especially with patents, right? Patents, you have to give us the information to make and use it because we want to share that with the world. We want others to be inspired by your invention so that they can help improve it. But with a trade secret, we do not want to know because that is your secret. That's the sauce that gives you an advantage over somebody else. What if you spent 3 years traveling the world finding companies that made certain parts so that you could then sell them to other people, but you understood that these companies were cheaper and faster than other companies? So you have this customer list. It's a secret, right? And you want it to remain a secret because that gives you an advantage over somebody else, right? So once again, trade secrets have to give you an advantage and they cannot be generally known. And you have to go out of your way to keep them a secret. All right. So you cannot just leave them out on a table for somebody to see, because if someone walks by and they see your trade secret, well, guess what? They didn't rob you. It's not like they physically opened your computer or broke into your house to get this information. It was openly available to them. So you have to make sure you go out of your way to keep it a secret. How do you lose a trade secret? Well, like we just talked about, failure to take adequate steps to prevent disclosure. You did not go out of your way to keep it a secret. Maybe you authorize the disclosure of your trade secret. If you authorize someone else to know, then that's not a trade secret anymore. Someone could reverse engineer your product. They could go into a store, they could buy it, they could take it home, break it apart, put it back together, and figure out what your secret is. And they haven't done anything bad, right? If they haven't broken any laws, they just bought the product, they took it apart, and they built it, and they figured out what it was. So these are all things you need to take in consideration, because trade secrets could last forever as long as they're a secret, but they also could last 6 months or a year. That's a risk you as the inventor need, and you need to strategize and understand what is more value to you. Is 20 years protection from the data filing if you go the patent route, or do you want to try to keep it a secret and potentially have that forever type protection, right? And so those are some things that you have to think about as an inventor. But that's why I think trade secrets are such a cool form of intellectual property, because they do offer that opposite advantage and disadvantages to patents. So that concludes my presentation today. I hope that you learned from this, and if you have any questions, please visit us at www.uspto.gov, and we would love to help answer your questions. There's a wealth of resources on our website, and you can reach out to our Office of Education. You can reach out to our Pro Se Inventors assistance line. We have all kinds of resources. We have a trademark assistance, we have patent assistance. There's all different kinds of assistance that you can come to on our website and seek help from. So hope this was helpful for you today, and good luck on your invention journeys. Take care.